reform will improve the nation's anti-money laundering rules, protect American communities from the harms caused by criminal and corrupt activity, and ensure the integrity of the nation's financial system. First up, I'm very happy to introduce Senator Sherrod Brown, ranking member of the Senate Banking and Housing Committee. Senator Brown has worked tirelessly with us at the FACT Coalition for years, particularly closely over the past 15 months, to move this reform across the finish line. He patiently worked with Chairman Crapo to hammer out a bipartisan agreement that could garner widespread support from both sides of the aisle. The Crapo-Brown Anti-Money Laundering Act was critical in generating the support necessary to attach this measure to the National Defense Authorization Act. If it wasn't for the leadership of you, Senator Brown, and your key staff, including Colin McInnes, we would never have gotten here. With that, over to you, Senator Brown, for opening remarks.
Thanks, Mr. Gary. Thanks for the chance to give me just a few minutes to talk a little bit about the history and the background and how this happened. And special thanks to the FACT Coalition for the work you did, Mr. Gary, Mr. Kalman, Ms. Kumar, all of you with Transparency International and Global Financial Integrity and the National District Attorney Associations. Mr. Gascoigne, thank you. And thanks for organizing the call and for, this is a really big deal to get this passed. And as you know, it took a long time. It was your persistence, your tenacity, your organizing were essential to securing this historic bipartisan overhaul of anti-money laundering laws, now in the final version of the National Defense Authorization Act. It's not quite over the line, but it's now very, very close. As the top Democrat on the Senate Banking and Housing Committee, this is something that my responsibility is to work on this for years with members of both parties, including Chairman Crapo, a Republican from Idaho, Senator Warner, Senator Doug Jones, who is leaving the Senate, Senator Wyden, Senator Whitehouse, and others. The Anti-Money Laundering Act and the Corporate Transparency Act will finally update and reform the tools we have to crack down on anonymous shell companies used for money laundering and other forms of illicit finance, and on big banks that enable criminals. Yesterday, I wanted to thank Colin too, as you did, for his tenacity on this, and it took all of that. Yesterday, I spoke with I'm really beginning to see how this is going to matter and how this is going to be carried out. In the last couple of days, I've spoken with Secretary of Treasury designee Janet Yellen about her role in this. Once we enact it, I'm still not quite there, but close. Talked to my U.S. Marshal in the Northern District in Ohio, who's been U.S. Marshal through presidents of both parties for about a decade and a half in the work he's doing. And I talked to a county sheriff in Northwest Ohio, who's in the city of Toledo, where they've had all kinds of challenges with sex trafficking and money laundering in that part of our state because of its access to interstate highways. The criminals, as we know, whether it's the anonymous shell companies, the sex traffickers laundering money, or the big banks that enable criminals, they abuse the U.S. financial system to launder money from drug trafficking and organized crime and Medicare and Medicaid fraud and illicit weapon sales and of course, human trafficking. Money laundering, too many people I think money laundering is a bit of a victimless crime. It is certainly not that. It directly hurts communities in my state. I see it, and across the nation, especially those torn apart by the addiction crisis. Sinaloa cartel actors, fentanyl traffickers have been destroying thousands of families in my state and across the country. They use money laundering to get their drug trade money in and out of the country. Human traffickers who prey on runaways and truck stops along major interstate highways in my state and across the country also use the financial system, as we know, to launder their profits. This bill finally requires comprehensive reporting by U.S. companies of their actual owners, so-called beneficial owners. No more hiding these abuses in anonymous shell companies. It also cracks down on bank officials who look the other way or actively aid money laundering. It provides for greater information exchange with law enforcement so that responsible banks can better track and report suspicious activities. If you're helping drug traders hide their illegal fentanyl profits, you deserve more than a slap on the wrist. Banks cannot be too big to jail. Laws can't treat them that way. That's why our bill requires expanded reporting to Congress on banks who abuse prosecution agreements with DOJ. We know that criminals have long been adjusting their tactics to get around our current laws. It's a bit of the step ahead of the sheriff metaphor. This bill will enable us to get ahead of them and stay ahead of them. And the work that you all do on this call is obviously central to that. One caveat, one potential problem, President Trump unfortunately is throwing another temper tantrum on the way out the door, threatening to veto this critical bipartisan package that passes every year and is vital to our national security. The bill overwhelmingly passed the House this week by a veto-proof majority of 335 to 78. Unfortunately, the Republican leader said if Trump vetoes, he's going to encourage his members to stick with the president. We'll see how that goes. I hope my Republican colleagues who voted for this bill stand up to the president on this. We expect a strong bipartisan vote in the Senate, so that it's important and that you all help us encourage and Republican senators to stand strong if in fact the president vetoes this bill. Local officials in all of our states will finally have the modern tools they need to protect their communities and bring these criminals to justice. That's why your work is so very important. So, Mr. Gary, thank you, and all of you on this call. I'm really appreciative of your efforts in helping us get this bill put together and passed and ultimately implemented the way that it should be. Thanks so much.
Thank you so much, Senator Brown, and we'll do everything we can to get this bill over the finish line.
Thanks, folks.
I would like to now turn to Lakshmi Kumar, who is the Policy Director at Global Financial Integrity, to dig a bit deeper into the overall problem and why disclosure of beneficial owners is so important. Lakshmi?
Thank you, Ian. Simply put, what is beneficial ownership? Beneficial ownership at its heart is knowing the individual that owns a company or an LLC. It is the bedrock of the international financial architecture because it is critical to both financial transparency as well as protecting the economic and financial health of a country. Now, going back in 2016, when the Panama Papers leaked, there was a huge flurry of interest because there was all of a sudden this recognition that it was kleptocrats, money launderers, corrupt officials the world over, as well as criminals were all using a very common structure to help evade law enforcement, which was the setting up of an anonymous company. But going back even further, the World Bank, when it did a 30-year study of grand corruption cases the world over, the one commonality that they found across the 30s and across over 200 grand corruption cases was the use of anonymous companies as a way to hide and move money from one jurisdiction to another. And perhaps even more startling was the fact that it was not a known tax haven or a known secrecy jurisdiction that was at the top of the list that helped hide and move these ill-gotten gains. It was countries like the US. The US was the #1 jurisdiction where anonymous companies were set up and where these monies were moved to help facilitate these grand corruption schemes. Since then, we've seen that the problem with not knowing who the individuals are that own a corporation or an LLC are critical because they affect almost every facet of American life. When we think more recently, when you talk about the problems going on in China, we can see that national security concerns like the Iranian government, their ability to evade US sanctions was easy because they were able to evade US sanctions by simply investing in the US by purchasing a skyscraper in Manhattan. In the same way, we see the ability of the US to affect and further our national security goals impeded by the fact that the ongoing humanitarian crisis amongst the Uyghurs in Xinjiang is affected by the fact that the Xinjiang Production and Construction Corporation, which is a paramilitary organization, has set up over 2,000 anonymous companies in the US to help facilitate their activities. And this doesn't just stop with national security concerns. As I said, it affects and pervades every facet of American life. When you talk about human trafficking, Polaris found that there over 9,000 illegal massage parlors that were set up in this country, 28% of them had no official records or business holders' names that could be tied back to an individual. And what I've often found is a really simplistic way that captures this problem is that when Global Financial Integrity did a study to see how difficult it is to sort of what kind of information is provided in the US, we found that in every single state, a public library asked you for more information to be provided to take out a book than was required to set up a company. And in one particular rather glaring example in Kentucky, we found that a biometric fingerprint was required to take out a book, but no human being individual name or actual address that could be tied to a company was required. Now, these examples that we talk about the use and abuse of anonymous companies affect national security, they affect human rights, but they're also sort of critical in affecting the US sort of economic might and economic security, because counterfeiters use anonymous shell companies to move products from countries like India and China to bring counterfeit pharmaceutical drugs into the US, which poses a critical health risk to the US and to its people. Now, as a final concluding thought, because I do realize that there are other fantastic speakers here who will be able to dig into more detail, I will say that you cannot think of a crime, you cannot think of an illicit activity in the world that does not at its heart require the formation of an anonymous company. And knowing who is behind it and the name of the individual behind it is the first and perhaps most critical step in finding a solution and also equipping law enforcement officials in this country to be able to adequately target and address the threats that are directed to the US, but also for the US to be able to advocate its own foreign policy and to sort of carry out its goals of democracy in the rest of the world. And I'll pass that on to, hand it over back to Ian.
Thank you, Lakshmi. Now turn to Frank Russo, who's the Director of Government and Legislative Affairs with the National District Attorneys Association. Frank, you can provide us with some perspective on why this is important to the district attorneys and your organization.
Thank you, Ian. I really appreciate it and appreciate the opportunity for the National District Attorneys Association to join today. And first, I'll start with who we are. We are the oldest and largest national organization representing over 5,000 state and local prosecutors throughout the country. And us and our partners at the Fraternal Order of Police, and obviously everyone on this call, have played a significant role in getting us to this exciting point of hopefully having this beneficial ownership language included in a signed and finalized defense authorization bill. I realize that our name is NDA and we're talking about the NDAA, so I will do my best not to confuse both. So as I think all of our partners will point out today, this vital legislation ensures that beneficial ownership information will be collected and stored to be lawfully viewed by law enforcement in appropriate cases. So as Lakshmi really pointed out, why is that important to our members? Well, the issue grew on our radar back in 2008, as Lakshmi pointed out, that the U.S. Attorney's Office for the Southern District of New York and the Manhattan District Attorney's Office began to investigate whether a building on Fifth Avenue was owned by foreign interests. Years of investigatory work and resource-intensive work by our members led to the discovery that the building was owned by the government of Iran in violation of U.S. sanctions. Shell corporations were at the heart of this illegal operation, and it was discovered that Iran had been profiting off the building for 3 decades. More often than not, law enforcement this is not the outcome that we see. More often than not, we are not able to discover who is truly behind many of these shell corporations and these financiers of criminal activity. That's evidenced by recent grand jury reports out of Manhattan highlighting the use of shell corporations to steal profitable title to residential buildings. And in Florida, where Lakshmi also pointed out, they're beginning to uncover large-scale human trafficking operations through networks of illicit massage parlors. What they're running into, they can't figure out who's financing and paying for these operations. Despite the hard work of federal, state, local, and tribal law enforcement, many times these investigations simply cannot identify who's at the top of the criminal food chain, allowing them to close these corporations down and move from community to community to continue committing harm and avoid accountability. Now, because of Congress's actions this week, state and local law enforcement will be able to access this information through appropriate protocols should there be an open criminal and civil investigation. As the end users of evidence collected through the investigative process, it is imperative that prosecutors have as much information as possible in order to determine the best course of action, whether to prosecute an individual or entity that may have committed a crime. Obviously, as we pointed out, beneficial ownership data collection is vital to this effort. It ensures our members, alongside our law enforcement partners, I mentioned the Fraternal Order of Police earlier, can conduct these thorough investigations. And we're confident this language actually assists in ending this problem. I think there's some miscommunication or misunderstanding on how this process works for law enforcement, that this may be the determinative factor in an investigation. It's actually not. It's actually what it really is a key building block in the long scale of an investigation that we are missing. And by putting that building block back in for our members, we are confident that we can now build up the chain to find those who are truly financing those illegal activities that are happening in our communities. And before I pass it on, I wanted to touch on one other point on the process side of things. Our members understand the importance in the course of every investigation through a law enforcement entity that we strike the right balance between public safety and respecting privacy concerns. And the beneficial ownership language accomplishes this. It accounts for both privacy concerns by ensuring we have appropriate protocols, ongoing investigative requirements, supervisory sign-off, contact with the judicial system, and then criminal penalties for misuse of the database to ensure that this information is only used in a targeted way, as I mentioned before, as a key building block in an investigation. With all of these tools done so in an appropriate process, we're confident, one, that we're respecting privacy rights, but two, that we're actually addressing and solving the problem that has been sitting at law enforcement's door for decades. So we're excited to work with our partners on this effort. We're excited to answer any questions you all have and really appreciate the opportunity to join.
Thanks so much, Frank. I'll now turn to Gary Kalman, who is the Director of Transparency International U.S. office. Gary has been in the trenches for many years, working to create solutions to this problem. And Gary will describe a bit more about what the Corporate Transparency Act will actually do.
Thank you, Ian, and thanks all to everyone on this panel and in the coalition for the incredible work to get us to this point. Proud to be a part of that coalition. Transparency International is a global anti-corruption organization operating in over 100 countries. The role of the U.S. office is to work on ways to improve and encourage the U.S. role in combating, in efforts to combat corruption, and using the authority and power of the United States to make sure that our own laws are up to what they need to be, as well as working through the international bodies. It's an exciting moment. We are on the cusp of passing a long sought after anti-corruption measure, along with my colleagues here today. As we mentioned, over the last 10 years, Transparency International has documented the dangers of secret ownership. This will be a milestone in unmasking the secrecy that allows the harms you've heard today. So what does the Corporate Transparency Act actually do? We thought we'd take a couple of minutes just to share the details of the bill. It is rare for such a simple measure to promise such an enormous impact. The law will require most corporations formed in the US to file beneficial ownership information with the federal government, as you've heard. The information required includes 4 readily known and accessible pieces of information: name, address, date of birth, and a government-issued ID number, like a driver's license or a passport. That's it. No business purpose, no financial information. The idea is to get this basic information into the hands of those who need it most and can use it to combat illicit finance. In the UK, which has a similar directory, it takes a few minutes of upkeep per year. The actual reported annual cost, as reported by small businesses with less than 50 employees, was approximately £2 per year. That translates to about $2.60. We think that that is a small price to pay to protect our financial system. The bill includes a comprehensive definition of beneficial owner to get at the true person or persons who control the company. No managers or stand-ins. The lawyer or accountant who sets up the company on behalf of a client can no longer list his or her name. When Venezuela's General Padrino set up a paint company in the US to launder stolen public funds, he had relatives listed to cover his tracks. That would no longer be legal, and the lawyers who set up those companies in that structure would be potentially liable. It would also put an infrastructure in place for the first time. The bill requires FinCEN to set up a database and a collection mechanism. This is an enormously important step. Establishing procedures and collecting the data will, as they found in the UK, help us to see patterns of what is most useful and where there are gaps that need to be closed. As Frank mentioned and described, state and local law enforcement will have access to the information, so will federal law enforcement officials, and even our international partners and allies who request the information through the appropriate processes and procedures. And it will also be available to the financial institutions who we call upon to assist us in protecting our financial system from abuse. The provisions are critically important. Collecting real valuable information, organizing it, and getting to those who will use it is critically important. The Financial Crimes Enforcement Network, or FinCEN, is the right place to hold this information. It is our nation's financial intelligence unit. It's charged with protecting the financial system from money laundering and other illicit finance. They already have agreements and systems in place with various partners to gather and share the information. For the first time, those who form corporations will have to report this information and are on the hook if they lie or cover up the true owners. If the UK example is any indication, this will be highly useful information and move us into a new era of enforcement of our anti-money laundering and anti-corruption laws. And with that, I will turn it back over to Ian.
Thank you so much, Gary. To round it out, we'll have Clark Gascoigne, who's a senior policy advisor with the FACT Coalition. Clark has been working for years promoting this legislation and addressing the problems that other people have highlighted. The FACT Coalition has had amazing success in developing a Strange Bedfellows Coalition, and Clark will give us a sense of the breadth and depth of the support for this legislation.
Thank you, Ian. And I just want to say that we are on the verge of celebrating the most significant anti-money laundering victory in a generation, due in large part to the widespread and growing support for reform. In addition to Senator Brown, his colleagues in Congress, and the organizations represented on this call, ending anonymous companies has the backing of a powerful and growing alliance of ideologically diverse constituencies. Supporters of reform include hundreds of national security experts and veterans from both Republican and Democratic administrations, as well as the entire law enforcement community, including local police, sheriffs, district attorneys like Frank's organization, state troopers, state narcotics officers, federal law enforcement officers, and federal prosecutors. The powerful National Association of Attorneys General also officially endorsed reform this year. Support also comes from major human rights organizations, anti-corruption advocates, mainline and evangelical faith leaders, anti-human trafficking organizations, global development NGOs, labor unions, tax fairness activists, and scholars of both conservative and liberal think tanks. There's also widespread private sector support too, notably including the entire banking and credit union industry, CEOs at major corporations, the real estate sector, small business owners, and large businesses concerned about securing their supply chains and curtailing the sale of counterfeit and pirated goods. The National Foreign Trade Council and the U.S. Council for International Business both support reform. And after leading the opposition to reform for a decade, the U.S. Chamber of Commerce officially endorsed reform over the summer. It's one of the few areas where the outgoing Trump administration agrees with the incoming Biden administration. It may be the first bill in the history of Congress that has the support of both Dow Chemical and Friends of the Earth. Heck, the state of Delaware even supports reform. It's thanks to all of this support that after more than a decade-long campaign, it now appears as though the days of abusing anonymous US companies are coming to an end. The landmark transparency reforms in the NDAA will improve our anti-money laundering rules, protect American communities from the harms caused by criminal and corrupt activity, and ensure the integrity of our financial system. At a time when it's easy to be cynical about Washington, the bipartisan process that led to this moment is an example of Congress at its best, with lawmakers like Senator Brown doggedly working across the aisle for years in good faith negotiations. Not only is this a historic anti-corruption victory, it's a reminder that good things can still happen in Washington. And with that, I'm happy to hand it back to Ian and Matt for questions.
Thanks, Clark. Matt, happy to have any questions if you could facilitate that.
Yeah, absolutely. Thank you to all the panelists for those remarks. If you have any questions, there's a Q&A button at the bottom of your screen where you should be able to insert questions. We have one already. So Senator Brown mentioned banks should not be too big to jail. Can someone offer detail on how or if this bill changes banks' exposure to prosecution should they enable money laundering?
Gary or Megan?
Sure, I'm happy to hop in on this one just quickly. So this bill provides additional fortification for the information that has been gathered. So when it relates to the banks, so the banks in the past have had what they call a customer due diligence rule, and they were responsible for knowing their customer. The value of this bill, however, and what changes is that a couple of things. One is it gives them a second check to actually verify that the information is correct, in addition to what the person is telling them who's sitting in their bank. But also, as I mentioned, it's a comprehensive definition. And so for the first time, we now, under the CDD rule, a number of the groups on this call and in the coalition were very concerned that the definition and what the banks were required to collect was actually, it could be a manager, it could be a stand-in. It just had to be somebody who had some knowledge about the company, but not necessarily the owners. And so I do think that the bill does strengthen the accountability process and the information that's going to be available. Whether or not we're going to put specific CEOs in jail, this bill, I don't think will do that. But I do think that banks are going to be more accountable because of the upgrading of the information that's now going to be required, and they're going to have to check. And if they turn a blind eye, there's now more culpability and accountability.
Great, thank you. And that question was from Zach Fox. Thank you, Zach. The next question from Asra Mustafa. This legislation has been in the works for years. What's changed now? How did supporters rally different groups to the cause, like banks, commerce, and law enforcement? Clark, maybe you can take this one.
Yeah, I mean, I would just say, I think you kind of answered some of your question there with the second sentence about how did we rally different supporters. I'd say what's changed now is a growing understanding among various constituencies about the harms that anonymous companies pose and the threats that they pose to our financial system, to our businesses. I want to give a lot of credit to Gary Kalman here, who, as the executive director of the FACT Coalition back in 2016, had the idea that, you know, anonymous shell companies are a problem for banks. If they're opening accounts, banks need to know who their customers are. It makes sense that rather than having to ask for that information every time, not really having a great place to verify that, wouldn't they rather that the companies disclose this when they are formed to the government, and then the banks, you know, could go and check a government database that they would, you know, be able to know has some integrity to it, and that would help them protect their institutions from money launderers. And so Gary went over and approached the Bank Policy Institute. And after, you know, talking with them for a few months, they came out and endorsed the bills, I think in August 2016 at the time. And that was really the start of it. You know, before that, the US Chamber of Commerce had sort of been one of the leading opponents to reform. The financial services sector was the first sort of sector of the business community to come out and endorse reform. I think it was after BPI, NAFQ came on board, and pretty quickly the rest of the banking and credit union trades did as well. Gary also then identified the realtors. He said, you know, there's a lot of concern about money laundering in real estate, and actually this seems like this would be helpful from a real estate perspective, if, you know, to know, you know, who's buying up real estate, and that the realtors might find this information useful. Gary and I then went over and talked to the realtors for about a year and a half. We held a conference and walked through the various pieces of the legislation. And after about that, I think it was February 2018, that the realtors, the National Association of Realtors, came out and endorsed reform. So, you know, there's sort of a, you know, it just took actually reaching out and talking to folks about how these entities harm them. With the larger businesses, you know, there was just sort of a growing concern about illicit trade. We did a report looking into our, you know, counterfeiters and pirated goods doing abusing anonymous companies, and actually it turns out they are, and there's plenty of examples. Illicit commerce is a massive industry, more than $500 billion a year, And I think the International Trademark Association and the International Chamber of Commerce estimate that that's going to grow to about $3 trillion a year over the next few years. So businesses are losing a ton of money by criminal networks that are selling counterfeit and pirated goods, and they're also, have huge reputational risks from that. So pretty quickly that after, some of that information got out there and the educational efforts took place, it wasn't long before groups like the U.S. Council for International Business and others signed on in support of the legislation.
Great, thank you, Clark. Okay, the next question is from Tim Fernholz. How will this provision interact with existing anonymous companies? Will their owners remain anonymous until the company changes hands?
I'm happy to answer that one, which is, so once the bill comes into effect, Treasury will have a year to put regulations in, and at that point, every new company that is formed will have to immediately disclose their beneficial owner. Now, for companies that were existing prior to that did not disclose that information, they will have a period of sort of 2 years in which they can transition and migrate. So there's that lag period, which gives them the time to update and provide that information to FinCEN. But naturally, within that period, if there is a change in ownership hands, they immediately have to then disclose ownership. So there are safeguards and provisions built within the legislation to account for that as well.
All right, I think we have time for a couple more. This next question is from Jean Whalen. Which parties are on the hook if someone lies about the true owners? Is it only the beneficial owner who is on the hook for fines and or criminal penalties, or is it the law firm / accountant also on the hook? And do most companies and LLCs use a law firm or accountant to set up anonymous companies?
I can jump in on this and others can add. The bill says that if you are willfully filing incorrect information with the government, then you are at fault and you are liable. So if the owner of a company goes online and files the information themselves and they lie, it's just them. If a lawyer, accountant, real estate agent, or other corporate formation agent files the information and puts their own name on, or Mickey Mouse, but they're the ones that filed, then they would also be liable. So it does cover who's ever involved in the fraud and the scam.
Yeah, I would say too, if you don't file though, then it would be the beneficial owner that would probably be on the hook if there is no applicant who actually files.
Great. Okay, I think that about does it for questions from the press. So thank you all so much for joining. If there are any follow-up questions for the panelists, my email is matt.lopez@berlinrosen.com. So feel free to shoot me an email and I'll get you an answer. Thanks so much.
Thanks, everyone.
Thank you.